So the date I sent this email was, when was it? Was Monday the 8th. This is after me leaving the courts, just confirming with the case officer, because when I arrived at the High Court on Monday the 8th of July at 12:04 p.m, and I submitted my interlocutory application and my exhibits over the counter, and that's actually the court copy. So with that, I was served by the counter staff, was a young female named Diane, and I wanted to actually speak to the case officer, but she had gone on lunch, I was told. When I got there, because of what I had spoken to in regards to the waiver fee, I kept a copy on the file, but I will do a separate video clip on that one. Information that I'm given over the counter by the court staff is clearly articulates an organised system where they knew it was me and have been instructed by somebody with what to say. But I will just, this is the email. Just before I move on to the next email, basically I'm just confirming that I've lodged my documents on the 8th of July with the case officer. Okay, so the status of this court hearing right now on the 5th of, which is Friday, that's the day I put in the memo, I got an email now from another case officer. But the case officer was Annie, now the case officer is Taoa. He sent me an email on the 5th of July 2024 to let me know. It looks like a copy and paste email by Anthony Waite. At the courts. Yeah, he is the judge's PA, from what my understanding with the email, and it looks like a copy and paste email, just notifying. But the email actually is dated Thursday, June the 27th, and in this email, everyone is sent the email on the June the 27th, except me. Oh, this is when I actually found out I had a new judge, and then the case officer had changed from Annie to Taoa. But this has been going on continuously since 2016. This is what's been happening. It's nothing new. This here is quite obvious that the courts ignored anything I have submitted or have asked the court. I mean, they're ignoring my emails, they're ignoring my phone calls. I'm basically a lockout situation. However, I'm working hard in this case and putting all the evidence together. But the courts and the Crown are just ignoring anything that I say. All the work that I've put and I've submitted, and so This email was sent from Anthony Waite, and he's actually the Associate Judge Gardner. Why this email is important, because I was notified by the courts on the 5th of July, after already given them the memo of my situation, of what had actually happened with the actual case. I also noticed that it said on Thursday, 27th of June, so I wasn't notified. I didn't know anything about this. But the courts and Crown have gone ahead, and you know, and they've changed everything. So it's quite obvious. It's one-sided evidence. They are neglecting my documents or have anything to do with it. So in this email, if you can see all the people that was sent the email except myself, because by rights the plaintiff always gets, you know, because it's the plaintiff's case. I lodged a complaint, so by rights and by law the plaintiff gets the first priority over the defendant. So in this case the defendant is the corporate body. Everyone knows in the criminal jurisdiction, or even in the civil jurisdiction here in New Zealand, by right and by law, when whoever lodges the complaint against the defendant, the plaintiff gets the first rights to everything, not the defendant. The other concern is that they're using their contacts within the courts to prejudice the case, you know, to have favour. Like there's a law in the Crimes Act about influencing a judge. Like, let me just find that for you actually. Let's go now. Okay, here it is. Okay, so the unfortunate reality is my case is definitely 100% against corporate bodies. But at this stage of my cases, which is now I'm dealing with the New Zealand Police, I'm definitely going through the same old cycle. So what I have found is that in a criminal jurisdiction, for several reasons, but what is actually relevant at this point in time with the evidence in regards to the case managing, the legal administration of the case by the courts and myself. But what I have found in all my cases is this law comes in place where there's been trading and influence. What you will actually realise at the end of all my court cases, the reason why we have the Department of Court system versus to what we are going through right now with this new age corporate body system. This law here is a Crimes Act law, trading and influence, and it has a 7 years penalty. So on cases where there's unlawful strikes or anything, you know, big cases where there's cases like mine involving conspiracy to commit murder and other historical things that have taken place, while I was working for my employer. Now I'm on the other side opposing the corporate bodies, which is my right to clear everything. But this here actually falls in place with this new age system where Crown, or you know, they're using their position or their position, you know, their power of position to actually influence their way in winning the case. So this here is actually a crime, and it actually falls under the Crimes Act, and it has a 7 year penalty. Okay, so basically this law is in place to stop bias and prejudice decisions made by a judge. So the old court system clearly separated all that. This is the reason why we have these laws, is so then one, the judge won't make a unlawful strike judgment The whole idea of these laws, of all these laws that are in place and still active, they've deleted a lot, and I think they should come back, and saying that the purpose of these laws is actually to protect the integrity of the government. It also protects the public welfare and the integrity of the courts. This here, trading influence, falls in my case. So as you can see, is actually live. The evidence is live, and this is my experience, but this has been my experience historically with everything, with all the court cases, the global Commonwealth gaming, people, secret societies, inciting mutiny. In my case, this case here definitely falls in place under trading and influence, where the Crown has, instead of having one concrete case officer to take over my case, they've mix match shift, like in the middle, changing people all the time. So lots of people are like, even my file is exploited like I'm exploited. And that's what's happened. But the old court system, the registrar's first priority has always been the judges, whereas the Crown is the Crown, whatever they're there for, whether they're the opposition, you know, whether they're defendant or prosecuting on behalf of a victim, they too are treated the same level as the other party, meaning that the judges don't, that they're not biased. Everything's done fairly as much as possible to, you know, to avoid the judges from making unlawful strikes. And obviously, the administration of law and justice is applicable, and that's why we have laws. Keeping in mind, I'm representing myself, and the laws here in New Zealand clearly we are allowed to do that. So this is the whole battlefield that I've been going against for the last 7 years or so. However, I just wanted to quickly felt it was relevant for me to show you the actual evidence in the Crimes Act for this new age system. So now it's all changed to the Criminal Procedure Act 2021. So this is how the new court system that is now in place. However, it is under now called the Criminal Procedure Act 2011. And in here, they've broken down and defined offences in categories. So in this case, category 1 offences and category 2 offences, all, you know, it's all there. But if you can look clearly at this rule here, or this law, this section of the legislation, it clearly defines that offences committed by a body corporate is punishable by only a fine. They can be fined depending on whatever the charge. It is category 2, 3, or 4. Okay, so but if you look in the category 4 case, it doesn't have there anything about a corporate body being charged. That is because anything that falls underneath category 4, if we go in here, it clearly articulates nothing but very serious criminal charges. And this is where my case is actually at, really. In reality, it is definitely a conspiracy by the corporate bodies. But it's not only just by the corporate bodies alone in New Zealand, it is a corporate body globally. because after researching and going through my own case personally, it came to the conclusion that since 2010, I have actually been used like a product, and for relationship scam and for Commonwealth promotion or Commonwealth competitive games. The only thing is I never consented to it, but I didn't know either. But it does explain the, the sabotaging and just the whole opposing rejection and everything that I was going through within the moment. So in this case also, I thought I might as well go through it while I'm at it. In my case, the acts of torture 1989 definitely falls in my case, okay? Legally by law, even though I am the plaintiff, I'm actually the victim. And in New Zealand, the victim's right overrides all the other corporate bodies. So that there has a 14-year penalty. So what I'm going to go and walk you through is the timeline for New Zealand Police. So the memo was first sent out on 15th of May 2024. So you can see I've sort of kind of just wrote it up on a whiteboard just to make it really easy and quick. Then on the 6th of June was my first memo to the courts. The case officer at this stage is Annie Kim. And on this memo, I had asked for an extension to the Friday the 21st of June 2024. And in this memo, I had mentioned in paragraph 2 that the applicant's position was I was going to apply for an interlocutory application under the High Court rules for a set-aside judgment for miscarriage of justice. So that was the first memo notification to the judge and to the courts and counsel. So at this stage there is no counsel. However, on the 6th of June 2024, I had a pre-arranged appointment to meet with the case officer because I wanted to review the New Zealand Police file and go over the documents that were in the file. And at this pre-arranged meeting, while I was going through the documents, the case officer was with me. So I asked her who was the actual counsel, because I hadn't been notified who the counsel was at this point of time. She said she was going to send me an email on the same date when I had this scheduled meeting with her, which was 6th of June 2024. And she had sent me the assigned counsel for the New Zealand Police case, and his name is Mark Haraboro. That was the assigned counsel by the courts. And with that, on the same evening, I sent all my legal documents and all the attachments to Mark. Then on the 18th of June 2024, I received an email from Katie Burbridge, and she has another name there, letting me know and advising me that she'd been instructed to be the counsel for the New Zealand Police case. Also, the other person was Sean Kinsler. However, I didn't send all the documents to her because I was protecting the privacy of my documentation. And not only that, like I said, the old rules is that, it's whoever's the first assigned counsel, that is by the courts, of course, because that's the court's job to assign counsels, and as the judge's instructions, it's not up to me. But because he was the assigned counsel and the courts had not notified me, Katie and Sean, as the assigned counsel, I didn't send all the documents to them, but I did say to them in my email. So I'm going to read what I said. I actually sent it to Katie, to Catherine, to the courts, in this case, the case officers, Annie Kim, Sean Kinsler, and Mark Haraborough. And in the email, I just said, "Good afternoon, sending this email as an acknowledgement and receipt of your email. I assume that Mark Haraborough or the courts have already forwarded all the necessary documents for this case. If you have not received them, please let me know as soon as possible. The documents that you should have by now are the notice of proceedings, statements of claim, plaintiff's lists of documents, and all the documents on the list of plaintiff's list of documents." So that's what I had sent to Mark Haraborough, who's also from Meredith Connell, and that was the end of that conversation. I'm just going through the timeline quickly as far as the case officers coming on board. So I didn't send my documents to Katie and Sean. My reason being is because the assigned case officer, according to the courts and myself, is Mark Haraborough, so they get the first privileges of the case, because these are the kind of things that happens in the background. Unless the judge or the courts have assigned them, then I can't, I won't forward my documents to them unless the courts have confirmed that with me. So that's another reason why I didn't want to send it to Mark Haraborough. Not only that, I was trying to protect the privacy of my documents, which is my right to do. I didn't want heaps of people reading it. Since this case has been pending, my file has been secretly exploited by the courts, different people all the time handling it. And this is the same too with other corporate bodies, example WINS, or in call centres. That's how everything about me is being secretly exploited by the corporate bodies involved, or I am a client too. Okay, so that's the reason why I thought that was important, because it's going to lead up to where the case is at right now. So just going down the bottom, I've written down here on the whiteboard, so you can see my High Court visits. This here alone is just for the New Zealand Police case. Okay, this is not including all the other cases I've gone through since I've been working on my cases. So this here is just the memo that I dropped off, which was the 6th of June, in response to Judge Lester's Judge Lester's minute, dated the 15th of May 2024, but Taoa was the one who was case managing at this point in time, and he sent it to me on the 17th of May 2024. He also sent the other one that was sent at the same time, dated 15th of May by Associate Judge Lester, was for the PSA that was sent on the judge had written that minute on the same date as the New Zealand Police. So there was two cases pending at the same time. But I did deal with the PSA first, and now I'm dealing with the New Zealand Police. But I didn't receive the memo until the 17th of May. I received it on Saturday from Taoa. So at this point in time, Taoa is actually the case officer. So with that, I did a minute asking the courts for an extension until the 21st of June. I was trying to, because I needed time to put this application in. I also notified the courts my intention of a set-aside judgment. However, life happened. I had so much going on, and as it turned out, I ended up being sick. I was doing a workplace cinema, it was actually to try and get back into the workforce, assigned by the work and income. I was doing all that in between, and I was actually in the middle of that while all this started happening with the court case. With that, I had to take leave off that to do the court cases, obviously, because it was my priority. As it turned out, I didn't get a chance to finish it. Time went on and I realized I needed more extension, so I made the time to the 5th of July 2024. With that, these are all the other in between visits, because it's a separate topic, which I want to go over the waiver fee form process and also the signing and the interlocutory application processes from what I've experienced. So then, by the 4th of July, I'd realised my printer wasn't working, and I had not finished putting all my documents together. But I did get them signed and sworn on the 3rd and the 4th. So you can see there, I went to the courts 3 times in 1 week. So I went there then by Thursday I realised my printer wasn't working. I couldn't finalise all my documents, and I needed over the weekend to finalise my documents. But the councils were aware, Meredith Connell were aware that they were due on the 8th of July. So this is me just locked down, concentrating on my court case. As it turned out, like I said, it wasn't ready. So I did another memo dated the 5th of July that you guys have already just watched on the same clip. I CC'd that memo to Sean Kienzler and to the case officer, and letting them know that the documents, or the original court documents, was not going to be ready until Monday, the 8th of July 2024. All that happened on that date, and that's where we're up to right now. I'm just going to do just a quick clip on the penalties of organisations and any government agencies when they, have done very serious misconducts or very serious violent offences. This includes anyone in government organisation according to the laws, the penalties and the actual pecuniary penalties, it's called, and criminal liability. So a case like mine is a very serious case, of course, because there's a lot of very serious indictable criminal offences. So in hindsight, the case itself is worth a lot more money, but according to the laws, and I'm just going through this because I think this is really important to make sure that they don't get away with it. With my situation I've been representing myself legally in court since 2016, but the case has been sabotaged and turned into a a monopoly game sort of a thing. So this is where I got the amount. This is not, it clearly says here, for an individual who commits an offence is liable to $500,000 fine, or both, which means they can get a conviction too. But it is a case-by-case basis. So individuals can actually get sued $500,000 and a conviction, or both. And over here it clearly says it's $10 million. Also for organisations, because organisations and corporate bodies are all treated as an individual. So this is where I got the $10 million for each organisation. So I thought I'd just put that up to make sure that they don't get away with it. But this is what is actually happening secretly behind the scene. I'm doing everything myself, so it's been frustrating. So when I go out, different people come out and they're playing games with my life when I'm by myself. It's dangerous, really. It's not acceptable for anyone to go through what I've gone through. But I don't know who's doing it. But the everything is staged, and they're staging people in my space when I do go out, just to go to the shops, and doing their indirect, whatever they want to call it,